Hello and welcome to Legal Angle, the show where we discuss issues in the news.
From a legal perspective. Hi, Ken. Nice to see you tonight.
Good to see you, Matt. I'm Ken Parker, and I'm here with my good friend, Matt Yaspin. And we've got a lot to talk about tonight, but before we get to it, we have something so special for our viewers.
Yes, it's exciting.
It's a multiple, you might even say. A factor of 2.
Indeed. So tonight, for the first time, we're moving our show from a half-hour format to a 1-hour format. We're doing this because we find there's a lot of issues in the news that we'd like to talk about from a legal perspective, and we often find ourselves rushed for time in our traditional 30-minute show. So we're doubling it.
And Matt, you may recall that when we first contemplated this show, we met over sushi and discussed the format, and we wanted an hour show, but we couldn't get an hour show because it wouldn't fit in the schedule.
That's right.
But
studio time is difficult.
Yeah, but thanks to the good people at New TV and their creativity, and other people just stopping making shows, I guess. I don't know. We've got a slot. So our regular slot will now be Tuesdays at 7 o'clock to 8 o'clock. So it was Tuesdays at 7 o'clock to 7:30. And of course, it gets repeated throughout the week at various times that I have no idea what they are. Do you have any idea, Matt?
No, but I do think it plays in syndication every Tuesday at 7 until we do another show.
Yeah, but also various other times of week. But Ken,
I have a lot of things memorized, but not that schedule.
It is on the web, though, on newtv.org. Yep. You can actually watch the episodes there. And you can also, I always wanted to say this, check your local listings.
And now you have, Ken, you can check that off your bucket list.
That's right. It wasn't really high on my list, but I think I never got to, and I got to say it on television too. Wonderful. All right. Well, to fully maximize and efficiently use this hour, we have our usual 3 topics. One of which we're going to try to do a lot with is our annual Supreme Court roundup. We're going to talk about some Supreme Court decisions. We're not going to talk about all the Supreme Court decisions. That would be too much, even for an hour show.
Yes, even for the Supreme Court's very limited current docket.
Right, and I don't think they're quite done yet, so we may need to come back and do some more.
We might. We've often done our Supreme Court roundup show in June, but we didn't get to do a show in March or April, I believe, and there have been a lot of big decisions coming down with more expected, so we thought it made sense.
We should have an hour and a half show, Matt. We missed 2 months.
Let's do an hour first.
I think that makes sense. And so in addition to these 3 topics, and spoiler alert, one of the topics has to do with intellectual property law. Oh, wait, no, most of them do. 2 of them. So we've got a copyright case.
To some degree, yeah. Well, it's funny, but you put a couple of lawyers who work in intellectual property because, in part, they find intellectual property fascinating, and lo and behold, they like to talk about intellectual property.
Yeah, so we've got a battle. We often talk about some of these same companies. So Mickey Mouse is doing battle with a cartoon character, Ron DeSantis. Sorry, I mean Governor of Florida.
Ron DeSantis.
Yes, right. That's what I meant. Which one is more comical? We'll see. Yeah. And so we're going to talk about that. And also, there's a performer, author, musician, author of music, I should say, Ed Sheeran. And occasionally, with a successful musician, people say, hey, that song you say you wrote, I actually wrote that, or at least part of it. Yeah. And so somebody sued the poor man over that. And we get to find out whether he still owns his song or not, and why in that discussion. And then, of course, for our Supreme Court roundup, we've got it all covered. Everything from the Andy Warhol, Prince controversy, to abortion pills, to some criminal conduct.
Right.
We've got, oh my gosh.
Well, let's dive on in, and we'll get to the Supreme Court cases.
I think we should dive in. But before we dive into the substance, we also have 2 special features that we're planning for our new 1-hour format. We don't know whether we'll get to them tonight, but
I just have to say that I love that we've doubled our time, and we don't know if we're going to get to the things we want to get to.
I know. Well, we're realistic too, right? We're balancing idealism and realism.
That's right,
The
Ken.
way every good candidate for public office should. What are you running for, Matt?
I'm not. But, as Shakespeare wrote, to thine own self be true, this above all things.
Yes, and so we will be true to our honesty about whether we'll actually get to these last two topics. And but just so people know, these are new features that we will integrate over the next couple of shows.
Right.
We may get to 0, 1, or 2 of them tonight, but one is an interview where I am going to interview Matt about what the heck he does with his time between 9 and 5 or whatever hours he's working. And what the heck is patent prosecution? Did the patent break a law? Do you need to put it in jail?
Spoiler, yes, that's what happened.
Okay. And secondly, we will talk a little bit about I will talk a little bit about the secret weapon, one of the secret weapons in intellectual property protection. And I call it secret because it has something that not a lot of people know about and how valuable it can be to their businesses. And on top of that, it's actually got the word secret in its title.
That's amazing.
So
what's it called, Ken? I must know.
I think you do, Matt. But let's put it this way. We could exchange information about it, perhaps trade information about this secret topic.
I don't get it.
Anyway.
All right, well, let's hope we get to it so that we don't keep
okay.
everyone in too much suspense.
Yeah, no, if they had to wait a month, they'll be knocking down our doors, right?
All right.
Okay, so what are we going to talk about first? Oh, we're going to talk about Disney.
Disney and Florida.
Okay. All right.
So what you see on the screen behind us here is a picture of Steamboat Willie, which is free of copyright now, I believe. At least
yeah, we talked about that last show,
that's right,
yes.
that version of Mickey Mouse, free of copyright in the public domain. And on the right, you see a photo of Ron DeSantis, the governor of Florida. Why do we have both of these, characters up at the same time, Ken?
Well, it seems that the governor of Florida is not happy with one of the nation's largest corporations and employers that happens to be in his state, one of his state's largest employers, if not its largest private employer. Disney had some sovereignty some authority over its land and had its own, essentially, its own municipality and could set its own rules for development. We still had to comply with environmental state laws and whatnot, but they acted like their own town, basically.
Right, the park where Disney World is.
Yes, well, it's Disney World, and they've got hotels, and they've got they own a large swath of what used to be swamp. It's just a tale for another time how they bought that.
Arguably still is, as every once in a while an alligator will come up and
yes,
sometimes attack somebody.
They have gotten the mosquitoes under control, though, pretty well, I think. But yeah, no, it is amazing how they acquired this land secretly through different buyers because the price would have gone way up if people knew Disney wanted to buy it. So that's an interesting story. You could Google it.
You can look it up.
Right, but that's not what we're talking about. We're talking about how this special district somehow got under Governor DeSantis' skin, how he's stuck in his craw, so to speak, and why he then worked with the legislature in Florida, and I use the term worked with loosely. He told them what to pass, and they passed a law that put a special board in charge, that basically allowed him to stack the board that's in charge of this district and put his people in charge of it. But just before this new board went into power, Disney cut a deal with the old board that basically for the foreseeable future, almost in perpetuity, gave them a lot of authority over their land.
So let's give folks a little background in case they don't know. The reason that Disney irritated Ron DeSantis, which is what precipitated all of this, is that DeSantis and the Florida legislature had passed a law that people call the Don't Say Gay law, where you can't discuss sexuality or anything having to do with sex or sexual orientation or gender identity in Florida classrooms. And Disney, along with many other people and corporations, spoke out against this.
Well, some people, Matt, think Disney was slow to speaking out, too, and were critical of Disney. Like, why aren't you speaking out more strongly? And finally, they did speak out against it.
And they did, and that irritated Ron DeSantis, and I'm sure other members of the Florida
and he's really
legislature.
declared war on Disney, which, again, is a little weird, right?
Well, it seems bonkers to go after your state's largest private employer. I mean, they bring a tremendous amount of money in, not just through the entertainment complex of Disney World, but the hotels and conferences.
And when tourists come to go to Disney World, they spend money at all these other restaurants and businesses.
Yeah.
Yeah,
both in the Disney municipality, I forget the name of the special
the
district, they have,
district, right.
but also in the area around it, and elsewhere in Orlando and elsewhere in Central Florida, and on their way to and from it, whether they're driving there from elsewhere in Florida or
Sure.
flown into Florida and drive to the park.
And Disney recently said there was a $1 billion project that they were going to bring offices and jobs to Florida from
that's
California, and they canceled it.
Well, that's right.
Over this.
Yeah. So before we get to that, Disney spoke out against the Don't Say Gay law. DeSantis was angry about it, and so DeSantis, as you said, tried to and did put in place a board that he could stack by adding people to it so that he would control the votes, or his allies would have the votes on this board that had oversight of the Disney municipality. And just before that went into effect, Disney signed a new contract with the
old board.
as you said. Now, one legal rule that I think we have to mention, because it's kind of a thorn in the side of every law student, and is also central to the plot of the movie The Descendants, which folks should go and see. It's a fun movie.
Okay.
Is the rule against perpetuities, which says that when you're establishing a contract or a trust, it can't last forever. It's not supposed to last forever. And so people put phrases in like, this contract will end when, so
Hell
and so
freezes over or something.
well, or when, when the last descendant of a person has
Right.
passed away.
Right.
But to make this contract as future-proof as possible, Disney tied it to the United Kingdom's royal line, and that their contract will stay in effect until the last of King Charles's descendants has passed away.
Yeah, very clever of the Disney lawyers.
Figuring they seem to live a long time, and they also have good health care.
Yeah, procreate adequately. So so there are a few interesting legal issues. So there was a state lawsuit in Florida where Florida, the state of Florida, sued Disney to enforce this, or actually the board sued Disney, I believe. But then, interestingly, Disney, rather than counterclaiming in state court, to use a cliche, but a true cliche, made a federal case out of it and Disney sued Florida in federal court. And the way that, if you listen to the radio talking about this and read the newspaper, a lot of what you'll read and hear is that Disney's argument, its legal argument, was a free speech argument. And everyone's like, well, corporations are people too. And here's the delicious irony of this is, Matt, the case that liberals hate, that I hate personally too, that is the case that is for corporations being people. Citizens United is actually the case that, to some extent, is coming to Disney's rescue here. So and of course, people who are not fans of DeSantis are now ironically cheering Citizens United to some extent, maybe not cheering it, but at least getting a silver lining out of Citizens United by saying, ha, because corporations are people under Citizens United and can make political speech, which is what Citizens United was about, Disney is allowed to criticize, and therefore the question is not whether the government has the power to regulate, but whether this is regulation or it's retaliation.
Right, exactly.
And so, but that's the argument you've heard about in the press, but there's a much more interesting, to me at least, undercurrent here. And really, if you read Disney's briefing and their lawsuit, the issue that they're bringing out is something that's going to really tempt this very conservative right-wing Supreme Court. You know what I'm getting at here, Matt?
Tell us, Ken.
The Contracts Clause. Now, what is the Contracts Clause? Well, the Contracts Clause basically it says that people have freedom to contract in this country. People, companies can make a contract. And the Supreme Court in the 1930s, during the New Deal, made a big deal out of and even leading up to that, was making a big deal out of the contracts clause
Right.
and saying, you know what, government can't regulate because you're interfering with private ability
Contracts.
to
Right. The ability to agree that I want to work 14-hour days, 7 days a week.
Exactly, you got it. Labor laws.
The ability to
Perfect.
agree that 10-year-olds should be able to go and work and earn a living if they want to.
The ability to
Don't
work
trample
7 days a week.
That's
What about,
right.
I mean,
Don't trample the freedom of those 10-year-olds.
Yes, right.
Don't they get to make this choice for themselves?
Or their parents get to make it for them, right? The freedom to contract was basically, I have a freedom to I own this land. Why can't I put things in the ground in the land?
Yeah,
it's
my waste oil, or I want to sell my bag of broken glass as an entertainment. Why can't I?
Yeah. Well, that's exactly it.
I'm a willing seller. That
Right.
you're a willing
Consumer
buyer
protection
of my
laws,
bag
environmental
of
laws,
my bag of
labor laws.
broken glass and rusty nails. Just choose a fair
Matt,
price.
I wouldn't buy broken glass and rusty nails from anyone other than you.
Thank you,
But I know
Ken.
you have the
They
finest.
are-
You have the finest broken glass and rusty nails.
They are top quality.
Now, I will, anyway, we won't take that to the next level. We could, but we won't.
No.
Now, the issue, of course, was that we had a president, Franklin Delano Roosevelt, who was confronting a national crisis in the Great Depression. And he said, we need to do a lot of things. Some of it was environmental. Most of it was about getting the economy going. So it was about regulating industry, and the Supreme Court was telling him, no, you can't do that. And then, of course, there was the famous switch in not time that saved 9.
Mm-hmm.
The Supreme Court relented, essentially. He was going to pack the court. He was going to add, he had the votes in Congress to add more justices to the Supreme Court, which would have allowed him to take control. And they finally said, no, never mind that whole contract clause thing. You can pass law. If the Congress passes laws and the president signs them, that'll be just fine, thank you. Now, what the heck does that have to do with Disney versus DeSantis? Well, Disney's argument in their lawsuit against the state of Florida and against this district is, hey, we have a freedom to contract. We're a company here. We had a contract here. So this conservative Supreme, they're essentially putting out catnip for the conservatives on the Supreme Court, saying, you can side with us against DeSantis and at the same time start to resuscitate this limitation on big government. So you've got the DeSantis argument on the one hand, which is, hey, they're too woke, let's shut them up. And on the other hand, you've got Disney saying, hey, you can't shut up corporations. And by the way, all those environmental regulations and labor laws, that stuff might be able to go by the wayside too if you help us out here. It's like, let's make a deal. So to me, that's what's fascinating about it.
Yeah. It will be really interesting to see what the Supreme Court does with this. It's...
Well, we don't know if it'll get to the Supreme Court, of course.
Okay.
But
good point, Ken. We don't know if it'll get to the Supreme Court. So when it gets to the Supreme Court, it'll be fun to see how the irony of the party of supposed small government that is attacking a company defends its actions, attacking a company, becoming the party of big intrusive government, trampling on businesses and what businesses want to do.
yeah, I think
In the free market. Nobody's making Disney say anything. They are just responding to, the beliefs of their leadership, their shareholders, and their customers. That's free market capitalism.
it is kind of ironic, isn't it?
Maybe a little.
Yeah. So, but I mean, I think DeSantis has clearly got one agenda and one agenda only. He wants to be president, and to be president, he has to beat Trump in the primary, and he's trying for the life of him to figure out how to out-Trump Trump. I don't know if it's possible to out-Trump Trump.
I don't know either, but I think you're absolutely right. And while we generally try to keep our show, as you know, to legal issues in the news, the fact is anybody running for president involves the law, and I think a clear takeaway is that DeSantis is using this to play not just to the voters in his state, but to Republican voters and Republican primary voters, especially in early states.
I don't see how this is going to help him in the general election, though, because Disney's a pretty popular company. I mean, there's a reason why they have Super Bowl ads. Where are you going now? You just won the Super Bowl. I'm going to Disney World. People love Disney.
Yeah.
So I don't get why battling Disney over like a stupid fight too. It's not like Disney was mistreating their employees or polluting the environment. I'm not saying they don't do those things, by the way, but he wasn't fighting them over things that they were actually doing that was bad, just criticizing him. Talk about thin-skinned. How's he going to do in a debate against Trump when Trump calls him whatever this
I'm not going to suggest names to call Ron DeSantis, although I think it's
a bleepity bleep.
I think it's fair to say that he's already not going to hire you or me as a political advisor.
Yeah.
Oh well.
I don't think we would enjoy that job either, Matt.
Governor, if you're listening, I don't think you'd like my advice.
Yes. It's a little late for following my advice, which would be don't do any of the things that you just did.
Yeah. All right. That's enough about Disney and DeSantis.
Matt, can you tell us about this this Ed Sheeran? Now, Ed Sheeran, "Shape of You," very popular song. I've heard it, and he's in a movie I really enjoyed. You know the movie I'm talking about?
Yeah, I think the song at issue here is "Thinking Out Loud."
Oh, sorry. But it is. But I'm saying he's got a popular song,
Yes.
"Shape of You."
Yes, I know it.
Yes, you know that song. The movie he's in that I really enjoyed is "Yesterday."
That movie is wonderful.
It's like
You should go
it
see
is
it.
the most feel-good movie I've seen literally in years. It's like
We might need to have a movie episode.
should we talk about movies or watch movies?
Yesterday, we've already brought up the Descendants.
Oh yeah, no, it's true. So yeah, we got a theme going.
Maybe for Oscar season we'll have a movie review and legal issues in the movies.
We should try something like that. But anyway, so yeah, Yesterday. What if? Yeah. Anyway, well, Google it. Yesterday, good movie.
Yes.
Beatles. Think Beatles. Anyway, what I want to ask you about, Matt, is so Ed Sheeran wrote some songs. He wrote a lot of songs.
Lots of songs.
Performed them. Very popular British performer. Maybe not as popular as the Beatles, but see Yesterday, you'll understand why. But he's been sued now a couple times, maybe more than a couple times, by people saying, "That's my song you're using," or "part of my song." Right. And recently, there was a really interesting copyright trial about
Thinking Out Loud.
Exactly.
Yeah, it went to a jury trial, and Ed Sheeran has prevailed so far. I don't know if the plaintiffs are going to appeal on that one. There's actually a second trial that was also just decided in front of the same judge. We can explain a little about the procedural history there, because it's interesting. That one, the losing plaintiff has said they will appeal. So it might keep going over Ed Sheeran and alleged copyright infringement. But if you'll forgive me, let's get it on and talk about these cases. So, thank you. So
I think you meant let's get on with it. I'm just going to say, Matt, I'm pretty sure let's get it on.
I meant
let's something different.
Let's very well. Let's get on with talking about the song by Ed Sheeran and the song that it's alleged to have copied, which is the 1973 Marvin Gaye hit, "Let's Get It On."
Yeah.
Hence my reference.
Oh, we should be playing this. Oh, we didn't think.
That's okay. Well,
all right.
We'll put that in post-production.
Okay.
Which we don't do. So Marvin.
Hypothetical, theoretical post-production.
Right. Marvin Gaye wrote this song, "Let's Get It On." You probably know it. It's famous.
Yes.
He co-wrote it with somebody named Ed Townsend. Now, Marvin Gaye and his heirs, because he's passed away, have been involved in a number of copyright lawsuits that have made the news for a time in the past several years. A Robin Thicke song was sued for copyright infringement of a different Marvin Gaye song.
Sure.
This one, not Marvin Gaye's estate, but Ed Townsend's estate. Ed Townsend is a man who co-wrote this song, "Let's Get It On," with Marvin Gaye. We'll have a picture of him up on the screen for you in a minute. That's on the screen here, Ed Sheeran and Marvin Gaye. Ed Townsend's family has sued and took it to trial and lost. That's Mr. Townsend. The jury held that the structure of the song was so commonplace, the chord progressions,
The building blocks of the song.
the building blocks of the song were so commonplace that if copyright infringement were found here, it would impinge a vast number of songs and the ability of artists to create new songs, because Marvin Gaye's estate or Ed Townsend's estate could stop people and
there's
hold
only a
them.
limited number of notes, and there's only a limited number of combinations of notes. And we talked about this before. You could write a computer program that would produce every combination of notes up to a certain number of notes, right? And then print that out, register the copyright to it, and every song ever written after that would infringe your copyright.
Right.
There's the point of silliness here. So I love what he did during this trial. The tactic Ed Sheeran employed?
Tell us.
He brought his guitar into the courtroom. Can you imagine on the witness stand there, and he literally illustrated, like he played some notes from each song, he played from other songs. And look, this basic building block, this chord progression, is in like 83,000 different songs. I didn't invent it, but it's in the public domain. Matt, this is something you and I have talked about so much.
Yes.
You've got to have a public domain of basic building blocks, or you can't write anything. Yeah. It's like saying, there's really only 5 plots to any story, right? There's, boy meets girl, kind of, or
right.
romance. You could use it more generically. There's lost something and found it.
Right.
There's, you can
revenge.
Go through, the plot archetype.
Yeah.
So
someone was wrong. There's the hero's journey.
So West Side Story infringes, Romeo and Juliet,
right.
which infringes Tristan and Isolde. Get the order, but in other words. Of course, you can't own the basic building blocks of scènes de faire, the
right.
stock characters.
I think that's exactly right, Ken. And I think it's worth looking at, an analogous doctrine in copyright law over written materials. You can't copyright anything that's very short. You can't copyright a single sentence. It's just not long enough, not creative enough. I suppose if you wrote a sentence that was
You didn't go to Newton South High School for English class.
I did not go to Newton South High School.
You didn't go to Newton South High School, and you didn't have Mr. Karras as your English teacher in junior year, it might have been sophomore year. And we read Faulkner, and there was one sentence in a chapter that is the entire chapter of the book, Matt.
You're such a lawyer. Okay. Yes,
I know exactly what
I
you mean.
misspoke. You can copyright a single sentence
if it's creative and long.
If it's long enough, not just creative.
Well, you can
but
copyright a haiku, right? So it's not just about length.
You may be able to if it's sufficiently creative. But
are you saying my haikus aren't sufficiently creative, Matt?
Ken, I'm not here to sit in judgment of the creativity of your haikus. But there's a de minimis requirement. Something has to be creative enough. In sculpture, for instance, you cannot, this is the Copyright Office's guidance, you cannot copyright a sculpture that is a perfect sphere. It doesn't matter how hard it was to make. And presumably, if you say carve and sculpt a sphere out of granite, you can't copyright it. It's a work of art. It may be expressive, but it doesn't embody enough creativity. And if you can go around copyrighting basic geometric shapes, you're going to impinge on the ability of anybody else to make other things. Just like you can't copyright a short, uncreative sentence, and you can't copyright a short building block of a musical composition.
And you can't copyright an organizational theory that's in the public domain. For example, alphabetical order. There's a famous case of the phone book. Somebody said, made their own phone directory, and the Supreme Court said, that is, or it might have been the Second Circuit Court of Feist Publications. I think it made it to the Supreme Court. But anyway, the idea that you've organized things in alphabetical order and someone else copied that, that's too obvious and therefore not creative enough.
Not creative enough. Well, that's the key.
That's what's here in this music, right? It's not creative enough to have the simple chord progressions.
Right, and to say that then you can protect it and stop others from doing it. The song as a whole, sure, I assume.
Doesn't sound anything like his song. That's the funny thing. If you listen to Ed Sheeran's song next to Let's Get It On, no one would think they were the same song.
Yeah.
I mean, there are times, by the way, when people actually sample from songs and take a big chunk of a song and put it into their song.
Sure.
That's a very different situation.
Right.
Then the question is, are they commenting on it? Are they, is there a fair use basis?
Right, are they expanding on it?
Is it a de minimis amount they're taking?
Right.
But this isn't what he was doing. But I think my favorite thing about this trial is that he sat there on the witness stand, just strumming away, playing chords, singing to the jury. How you get that kind of entertainment in the courtroom as a juror? You're going, I'm siding with him.
Yeah. Yeah, it's easy to see why his attorneys were happy to put him on the stage. I mean, plus he's, charismatic and a terrific performer.
And by the way, you know what he said also in trial? He said, if I lose this case, he said this in front of the jury, I'm quitting, I'm done. Because I can't own anything. And,
Yeah.
what would you think of that if you were sitting in the jury box, right?
But it's a fair point, even if you were inclined to dismiss that as a hyperbolic threat.
Mm-hmm.
If his song, Thinking Out Loud, is held to infringe, Let's Get It On, how can you expect people to write music and not feel like there's a target on their back? Not for everything, right?
And if they're successful, because if I wrote a song like that and played it for you and played it here on New TV,
nobody's going to come after you.
Nobody's going to come after me. No, because
unless you've got a wonderful voice that I haven't heard. I can assure you, if it were me performing,
honestly,
nobody would care.
Honestly, even if I did, which I don't, even if I did have a wonderful voice, if I weren't making lots of green paper, it's not going to be relevant to anybody's lawsuit.
Right.
That's what it really comes down to.
And I think that's, as you've said, the key common theme in these copyright lawsuits over pop songs recently. They've targeted popular songs by popular successful artists, Ed Sheeran, Robin Thicke, many more, because they've got deep pockets.
Yeah, and sometimes, frankly, by the way, the lawyering and the experts have been too good and the plaintiffs have won. In other words, there have been songs that really nobody took anything, but they have these beautiful graphics and expert witnesses, and they say, look, this element is taken this, and they superimpose things, and by the time you're done looking, you're like, oh, wow, they took the whole thing. But if you go back and listen to the songs, they didn't. I mean, but they win anyway because they bedazzle the jury, and that is a risk to stifle creativity. So I'm very glad that Ed Sheeran is still thinking out loud and singing out loud, and he won't be stopped by this kind of what I think is somewhat frivolous litigation. Matt?
Let's be happy he can continue to get on his music writing.
Okay, I like the way you phrased that. Get on with his music, okay.
Yes, that's what I meant, get on with his music writing.
Okay. All right, I'm not going to, you set up an obvious punchline, but this is a family-friendly program, so I'm not even going to say it. Not that kids are necessarily going to want to hear about issues in the news from a legal perspective, but we'll leave it right there.
Yes, let's do that.
What do you say we talk about our nation's highest court? Oh, you know what? Instead of talking about our nation's highest court, Matt, let's talk about the only federal judges in the country with no ethics code. Shall we talk about that group of people, the decisions by that group of 9 people?
Okay, so we're not going to talk about the Supreme Court?
Oh, we will talk about the Supreme Court because that is the group of people we're talking.
Oh, yeah, that's right. It is the Supreme Court because unlike all of the lower courts which they've established and which they oversee and for which there are codes of ethics, written codes of ethics with which the judges and staff have to comply, there are none for the Supreme Court.
Now, why is that? Because they're just so good, they're never going to have an ethical violation? Like, for example, Justice Thomas would never have an ethical violation.
Nor would any of the rest of them. I think the theory has been that the Supreme Court is composed of people who are so wise and so pure and so blameless that they don't need a written code of ethics.
Is that what they're telling themselves?
That's what they've told themselves for decades.
Yeah.
And guess what? It's not true.
Yeah, the only group of people by that name that I think are that fabulous would be the Supremes, not the Supreme Court. They are fabulous, but
they are fabulous.
Going with our music theme, but
yes. Well, the Supreme Court, which is 9 people but doesn't have to be. There's no number prescribed in the Constitution. As we've talked about on the show before,
everything's coming together, man.
I know.
I feel like this connectivity is going on.
I know. I'm glad we have an hour. The Supreme Court has no code of ethics, and to my knowledge, it never has. They've just not ever written one down for themselves. And when they've been called on it recently, they, mostly through...
Matt, may I just interrupt to ask?
Sure.
What do you mean called on it? Has someone on the Supreme Court allegedly done something wrong?
So, legal issues in the news. Yes. Yes, over and over and over. It feels like it's easy to focus on Justice Clarence Thomas for this, but he's far from the only one, and
Have we talked about this? Because this is really this Mr. Crow.
No, I don't think we have.
I think it's worth a minute before we get into the substance of the decisions.
So ProPublica, an investigative journalism source, started investigating, I'm not certain how long ago, and started releasing their findings, and whether they released them piecemeal because they wanted them to have greater effect and not just release, here are 5.
I think we did talk about this at one point. This is sounding very familiar. Or maybe no, you and I talked about it.
You and I have spoken about it, but not on the show because we haven't had a show since this news started.
Well, this is so
the
what
news
was
started to break.
ProPublica looking into, Matt?
They were looking into, I believe at first, Clarence Thomas's, let's call them business dealings, because they certainly look like business dealings, with a billionaire named Harlan Crow, who...
And but just an aside, is that not the most awesome supervillain name, Harlan Crow? I mean, come on.
I think it actually is a supervillain name. I'm pretty sure there are villains named Harlan and named Crow.
Anyway, but I mean, you put them together, it's just...
It's quite a name. So for years, decades, this person, Harlan Crow, who met Clarence Thomas, met him not just through happenstance, but by inviting him to an event, to I think it was his private box at a sporting event or a concert.
Well, but Matt, what's the problem with making friends with the Supreme Court justice? It's not like Harlan Crow had any agenda or issues before the Supreme Court, did he?
Well, Ken, it's funny you ask that, but one of the things that tends to happen with very wealthy people is that they are involved in lawsuits, either because it's things that they want or because they get sued, whether it's unfair that they're being sued, that they're just being targeted because they're wealthy. That does happen, as we were just talking about with copyright cases, or because their businesses, I don't know, I'm not saying anything about Harlan Crow's businesses because I'm not familiar with why, but things explode, things derail, things wind up violating labor laws. That sort of thing happens.
But I mean, all kidding aside, Matt, I mean, he has had clear interest and articulated interest in a number of matters before the Supreme Court, and has basically admitted he was trying to curry favor with Justice Thomas, to the point where he was recently asked by a reporter, because they said, well, all his dealings, he gave, we'll get to it in a minute, but huge amounts of money to Clarence Thomas, like bought a piece of property for way over its value. But he said, I did it as a friend. And then here's the key question. Would you be friends with Clarence Thomas if he weren't on the Supreme Court? And you remember what his answer to that was?
No, what did he say?
He said, I don't know. But I mean, clearly.
I'm sure he doesn't. So
he made it clear. He didn't even pretend. Oh, of course we'd still be friends.
Well,
it's all about
I believe,
access to power. There's a word for this, though, really. It's one of those famous 5-letter words. It's called bribe. That's what's going on here.
I was going to say corruption, but bribe is shorter, so well done.
Go ahead, Matt. Tell us about these payments.
So some of them, over the past course of, decades, have been expensive vacations, where Clarence Thomas and his wife Ginny, who is a treasonous insurrectionist, participated in the January 6th insurrection, and a well-paid Republican lobbyist and strategist for decades, have been treated to flights on private jets, owned or rented by Harlan Crow, have been treated to expensive vacations at resorts or at Mr. Crow's properties for themselves and their family members, and things like, as you said, buying property, I believe a couple of properties, I think in Pinpoint, Georgia, where Clarence Thomas grew up, but where his mom lived and still lives. Harlan Crow is still her landlord. They pay rent to him, but not much, because he's doing it as a friend. Right. They've also paid for Clarence and Ginny Thomas's grandnephew, I believe.
Who they raised as a son.
Who they've raised as their own child, with some cockamamie argument about how they didn't have to disclose the, I believe, about $6,400 per month in private school tuition
and
paid on behalf, because the disclosure forms say you only have to disclose that sort of payment if it's for a dependent, like a child, son or daughter.
There's precedent.
And this grandnephew is not a son or daughter. Obviously, either Clarence Thomas, one, doesn't understand the law and the disclosure requirements, or two, lied.
But he clearly
and which one is more disturbing? That he's lying, or that he's bad at the job that he is one of 9 people supposed to be the final arbiter on, understanding the law. He doesn't.
Matt, this is not a multiple choice question. A and B can both be true. I just want to point that out.
That's great. So what do you say, Ken?
Well, I mean, I'm pretty sure B is true because, I mean, at least with respect to this particular issue, he did understand the law because of his, you look at his other disclosures, not from Harlan Crow. Someone else paid a month's tuition for the same child, and he disclosed that. So pretty clearly he understands he's supposed to disclose. But I mean, whether he's bad at his job, we can talk about in a minute when we grade the Supreme Court. I think we should probably get on to that. Let's talk about a few. Okay.
Before we do, let's just say about ethics in the Supreme Court. It's not only Clarence Thomas. There have been revelations about Neil Gorsuch selling a property and not disclosing it, and then saying, "Oh, I did an oopsie. I didn't realize I was supposed to." Again, are you a liar, or are you just bad at the job that you are supposed to be one of the 9 best people at in the country? Well, and I am certain the revelations will not stop there.
Yeah, well, I mean, here's the thing. Even if someone is a paragon of virtue, they're in public office, an ethics code ought to apply to them. They have to, there have to be ethics rules. I don't care how fabulous somebody appears to be.
Yes.
Even the Supremes should have are not above the law.
And
even
in
the
addition,
President of the United States is not above the law, as we know, because a former president is being prosecuted. The Supreme Court justices, should not be above the law. It's just not right.
That's right. And the judicial branch should have an independent inspector general, just as the executive and legislative branches do. It's absurd that when, as happened this past year, last spring, in advance of the Dobbs decision that struck down decades of precedent in the form of striking down Roe versus Wade, when that was leaked, the Supreme Court investigated itself with special, not really very investigative investigations of the 9 justices, while staff and Supreme Court clerks were subjected to much more stringent interrogations. That has to end. The Supreme Court and the entire judicial branch needs an independent investigator general.
Indeed,
okay,
agree.
I'm off my soapbox about that.
No, I totally agree, Matt. And I'm just thinking, I've just been rattling around in my head the statement that you've made saying maybe the Supreme Court justices aren't good at their job. Let's look at some decisions and see how good they are at their job. So I'll tell you what, we'll just alternate and talk about some of these.
That sounds great.
I'm gonna start with, I love copyright law. You got to talk about copyright law a little bit earlier. My turn.
Excellent.
So Andy Warhol, maybe we can get this up on the screen. Andy Warhol made some paintings.
He did.
Most famously, perhaps, Campbell soup cans, lined them up. People love it. Not sure why, but it's a thing, right?
It is.
He's, I guess he's called like a pop culture artist of some kind, something like that. So this is another guy who's very well known. This man used to be known as the artist formerly known as Prince. Then he became Prince again. That's a whole nother issue of contract law and why he couldn't be called Prince for a while. But he was a very popular guy. Purple Rain, very popular musical composition.
Yep.
A movie too. We were talking movies. That's our 3rd movie reference of the night.
Wow.
So at one point, an artist was commissioned to do a magazine cover of Mr. Prince. I don't know. of Prince. Yes, of the Prince. No, and so she was like, "Oh wow, I need a photograph to work off." Or the artist, I'm sorry, the company wanted a photograph to work off of, and so they found this lovely photograph on the left here, and they said, to the photographer, we'd like a license to make one magazine cover based on it. And the photographer said, sure, I'll grant you that license. So they entered into a contract, and sure enough, I think it was a cover of Rolling Stone magazine. His last name is Nelson. It's Mr. Nelson, by the way. It's his actual Prince Rogers Nelson is his name. But anyway, he does have a last name, or it did at one point. Anyway, so she made this, this company, this advertising company, said we'll make a cover, and they took a picture of that. So Andy Warhol made a whole series of. They commissioned Andy Warhol to make a picture, just one actually, painting, based on this photograph of Prince, and it was purple, and they called it Purple Prince. And they put it on the cover of their magazine. And all was well and good. But that's not purple. We'll get there. Andy Warhol, being the creative guy that he was, and maybe this ad agency decided to give him some extra leeway, had him make a whole series of Princes, a blue one and a yellow one, and yes, an orange one. They made a whole lot of Prince.
Prince?
Prince of Prince? I don't know. Principally, sorry. I'm glad this didn't happen in a principality, or we'd be really lost.
Ken, what's the larger principle that's at play here?
Yeah, let's get to that. So anyway, the question is whether what they did was well, first of all, we know it wasn't allowed under the contract. So by the way, the photographer didn't know that that Andy Warhol had made all these other pictures until years later. This orange Prince showed up on the cover of a different magazine. And she's like, wait a second, that's my photograph it's based on. Just like the purple one I authorized. I didn't authorize an orange one, though, or even putting the purple one on another magazine. So she sued about this. And the defense was, well, this is transformative. It's fair use. Well, question here, if it were so transformative, why'd they go get a license in the first place? Well, maybe it was out of an abundance of caution, right? They just didn't want to.
Maybe so. Ken, just explain for our viewers, please, what does transformative mean? And I'll try not to refer to the movies and the toys, the Transformers.
You just did, though. So
darn, I did.
Okay. So there are 4 tests to determine whether something can be considered fair use. Now, what is fair use? Fair use is a defense to copyright infringement. It doesn't mean something is not infringing. It means it's okay that it infringes. In other words, you can say, well, I'll give you the...
I took your song. I took your photograph.
Right. So infringing means, to infringe copyright literally means to take or copy or use somebody's copyrighted material without permission. If Matt, you take one of my haikus and go sell copies of it without my permission, assuming it has enough creativity to be copyrightable.
Yes.
You'd be infringing my copyright. Of course, Matt, you have permission to do whatever you want with my haikus.
I'll have my lawyer call you to formalize that.
We'll work out a licensing agreement. But if you infringe somebody's copyright, you can say, aha, I had no choice. Well, when do you have no choice? Say you're reviewing a movie. We're talking about movies. And you want to discuss some element of it, so you quote from it, or reviewing a book, and so you say, this writing is terrible. Ken, your haiku is awful, it doesn't rhyme. And you want to quote a couple lines of my haiku and point out, you got the wrong number of syllables, Ken, that's not even a haiku.
Right.
Well, you need to quote it to show what's wrong with my haiku, right? You need to quote from a movie or a book to illustrate the dialogue in this movie is terrible. Let's quote some dialogue. And so that's fair use because you're commenting on it. So another type of fair use, though, is if you're just taking something and you're turning it into something totally different. So that is considered to be transformative. In other words, if you're taking something that was made for one purpose and using it for a totally different purpose. So
is this... the issue was whether...
that was transformative.
Yeah, whether these magazine covers really took the photo and transformed it into something different.
Yeah, and the answer, and I have to give the Supreme Court an A on this one, Matt. They got it right. They said, no, that's not transformative. That's a derivative work. In other words, you're taking something, it's like you're taking... I don't know. Say I make my own Star Wars movie, and I've got Darth Vader in it. Maybe or maybe I take my favorite novel and I want to make a movie out of it. That's a derivative work. This is a derivative work. It's a painting based on a photograph. This is a classic derivative work. It is so obviously a derivative work that I honestly don't understand how this was a 7-2 Supreme Court decision. 2 Supreme Court justices actually thought that this was transformative in some way.
Yeah.
It's beyond me. Matt, any thoughts on this one?
I agree with you. And the 2 who dissented, I believe it was Roberts and Kagan.
Opposite ends of the political spectrum too, right?
Yeah, that's one of the funny things about IP. It doesn't break down along typical political lines often, not always, often. I believe the rationale was that that this would stifle creativity.
Yeah, I mean, it's abandons the law's historical concern for blocking creativity with demands for permission and payment. But I need permission if I want to make a movie out of somebody else's book, don't I, Matt?
Yeah.
I don't get to do that.
Yeah, I don't really understand how they, what facts they were looking at and why they concluded that, holding this to be infringement and not a transformative fair use would stifle creativity. I mean, it's not all that creative. It's just taking the photo and coloring it. You wipe out the contrast and you put a color in the
I
background.
mean, you could have AI do that these days, honestly.
We're not going to get into AI today. We don't have time.
Next show. All right. I think you and I, so what's your grade for the Supreme Court on this one?
A.
Okay.
Yeah, easy one.
Yeah,
for,
all right.
For me.
Okay. Matt, there's another IP Supreme Court decision. Why don't you tell us about this patent case here?
Yeah, so this one needs a little background. It's Amgen versus Sanofi. Sanofi, forgive me if I'm mispronouncing their name.
They don't even know how to pronounce it, Matt, so you're fine.
That's a relief. Amgen had a couple of patent applications.
So who's Amgen?
They're a pharma company. These particular applications were for antibodies involved in metabolizing a cholesterol lipoprotein, low-density lipoprotein. But not just a couple of antibodies. It was to an entire class of antibodies, which potentially could be, hundreds or thousands or many thousands, tens of thousands of antibodies, because you can make different molecules with the same functional components, change a few atoms here and there, and come up with a different molecule that could work as, as the metabolite, as an antibody to bind to these proteins. Well,
so why do we care about that, Matt? Can you explain what the value of that is?
Well, the value of it pharmaceutically?
Yeah.
I mean, it's to
why does someone want to bind things to proteins? What's that about?
Oh, because heart disease is still the leading killer.
Well, how does it help deal with heart disease?
It helps to lower cholesterol.
Okay. So
I
just want to make sure this was clear. This is a drug that helps lower cholesterol.
It's to assist in metabolizing cholesterol.
Okay.
That's the point of these particular pharma products.
Okay. And so other people should be able to make drugs that do the same thing, right? But they can't do it if they do it the same way.
Well,
so, right? Or
so there's a couple of things here. One, sure, people should be able to make other drugs that do the same thing, but patents aren't to functions. They are to particular things, right? Amgen wasn't trying to protect the function of lowering cholesterol with a drug or with a chemical. They were trying to protect a particular, and this was the problem for them, class of chemicals that will help to metabolize some cholesterol molecules. Okay, the problem that Amgen has is that they didn't write a patent application that was just to these, say 3 chemicals, antibodies, or these 10, or these 100. They wrote it for a class, and class in this context means many, potentially many, without defining what each of them were.
Now, I know, Matt, that patents get a lot of review by the USPTO, by a patent examiner. If it was too broad, how to get approved? Doesn't the USPTO examiner go, no, 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 and finally yes? Isn't that kind of
Well, I can tell you that is often exactly how the process of patent prosecution feels. No, 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 and then yes. There are a number of hurdles that a patent application has to cross in order to get a patent issued. One of them is called enablement. You have to describe in your invention, which means text and drawings. In theory, drawings are optional, but in practice, they're required.
How someone with some skill in the art might do it, right?
Right. You have to enable someone. You know, let's say you're another chemical engineer, and I want to write down instructions for you how to do this, how to make a chemical that will lower cholesterol in this way. Well, I have to write down the steps you'd take. And in these applications, Amgen wasn't specific enough. They said, we're going to claim this class of antibodies that does this.
So you could, if I were that chemist, I couldn't follow the instructions and do it then?
That's what the Supreme Court said eventually. A lower court said that, and the Supreme Court upheld it. The problem was that they were specific in part and vague in part, I believe, in their directions for how to make the chemicals.
Okay. And the question, Matt, is did the Supreme Court get it right?
Well, it's hard to know.
Oh, you not having an opinion? Wait, let me write down the date and the time. Matt Yaspin isn't sure.
It's hard to know because biology is complex. I think that the Supreme Court got this correct, that you have to have the specifics in the application of what the invention is and how to make it. Not just this is part of it, but this is all of it. And these two Amgen patent applications didn't have that level of specificity. They had, here's what you want for part of it, the rest of it you can try and see what works, and that was the problem for them, the vague part of their application that said experiment and try and see what works. That was held to be not enough instruction to meet the enablement requirement, and I think the Supreme Court is correct about that part.
Okay, you're going to give him an A?
I am.
All right. We only had a couple minutes left in the show, Matt. So real quick, you want me to do one more of these? And
yes, please.
Let's talk about this this Twitter decision.
Yeah.
So
you got 60 seconds.
Yeah, I don't even know if I have to. So basically, there were two cases before the Supreme Court: a Twitter case and a Google case. The Twitter case is, I'm going to say this wrong, Twitter versus Tamina, and the idea is basically, when the internet was in its early stages, Congress said, hey, we want to protect this thing. We don't want anybody who has a website or has a service on the internet to be liable for everything that Matt Yaspin and Ken Parker and anybody else posts to this website.
Right.
And so they had a carve out basically which says, if you don't put it there, if you just create a forum and somebody puts something there, as long as you take it down once you find out there's something wrong with it, you've got essentially a safe harbor under Section 230.
Right.
And there's been a lot of question about what kind of policing needs to be done and what kind of, and whether hate speech can be regulated. And there is a specific carve out since then by Congress for child exploitation. But what this case was about is, what if you're promoting that content? What if you have an algorithm that's got something that's hateful and horrible? And
right, because if I may, because I know we need to wrap up, because then the platform is acting like not just a neutral bulletin board, they're acting like a publisher.
So and so but the Supreme Court had a chance to say that we're going to draw a line. You can't promote it. I got 10 seconds here, Matt. They had a chance to do that, and you know what they did? They punted. They said, you know what? We're not even going to reach that issue. We're just going to say there was no underlying, the terrorist incidents weren't caused by this. So they didn't address the underlying issue. So we'll have to wait for the next chapter. So I'm going to give them an I for incomplete on this decision. It's like their dissertation. They're working on their dissertation, and they have like, it's over 2 semesters.
Yeah.
It won't be redundant. Anyway,
Ken, this has been a real pleasure. It's such a fun show. I'm so glad we had an hour, and I'm so happy that we're still running.
You know what we're going to do, though? We have a bunch more Supreme Court decisions to talk about. So on the 4th,
check with us in June.
Yeah, 4th Tuesday in June. Be with us at 7 p.m. Check your local listings. Right. And we will talk more Supreme Court decisions. There'll be more out by then. We'll finish the ones that we have on the table tonight.
Yeah.
And in addition to that, Matt, I think we will very likely talk about issues in the news
from a legal perspective. Always.
Thanks, Matt.
Thank you, Ken.
Thanks to our fabulous crew. Thanks to Aiden. Thanks to Will. Thanks to Dan, John.
Kathleen, everybody. Couldn't do this without you. Thank you, folks.
And thanks to everyone at home for watching. And please join us again Tuesday, 4th Tuesday in June for more Legal Angle. Good night.
Take care.